First of all, thank you for having me. I know this immigration issue has been a really heated topic in the last couple of years, so I really appreciate you guys taking the time to learn about the issue because, as Alicia said, this is a topic that definitely impacts our community and the communities that we serve. So I thought I would just kind of start off by giving you guys an introduction to the Northwest Immigrant Rights Project, where I work and what we do, and basically just give you an overview of what's been happening under this administration, more or less in chronological order, and basically just let me rant for an hour about what's been going on. And then I'll kind of end with a little update on the litigations that we've been involved with locally and as well as nationwide litigation, and some of the resources if you have clients who may need or patients that may need our services. So the Northwest Immigrant Rights Project, or NIRP for short, we're the only nonprofit organization in the state of Washington that provides comprehensive immigration legal services to low-income immigrants and refugees. We focus primarily on direct legal representation, so individual representation cases, and that's because some of you may know is that for immigration court proceedings, there is no right to appointed counsel. So immigrants, regardless of their educational level, that they don't understand complicated US immigration law, like most people, who may not even be able to speak English, are somehow expected to represent themselves against trained government prosecutors. So this is kind of where we stepped in to try to provide them with legal services and assistance in court. And that this no right to appointed counsel thing applies regardless of whether you're detained or not, regardless of your age. So sometimes you even see kids, I think I heard that the youngest so far is at 53 or 56 weeks old in court. So even though our bread and butter are those direct legal individual cases, what really gets us reputation, and some people may hear about us in the news, are the class action large impact litigation cases. But we also engage in systematic advocacy and community education, especially in the last few years. We've been doing a lot of know your rights trainings, workshops, clinics all across the state. We have 4 offices. Our main office in Seattle is just down the hill in Pioneer Square, just a couple blocks away from the immigration court, actually. And then we also have an office in Tacoma, which serves primarily those who are detained at the Northwest Immigration Detention Center. And then we also have 2 offices in Eastern Washington, in Granger and Wenatchee, that primarily serve the farm worker population along the Central Valley. So starting off with the travel ban, which is probably the most headline-grabbing case since this administration. So, rolling back, if you all remember, just a few days after President Trump took in office, he signed an executive order, true to his campaign promise of keeping out Muslims, and signed the first travel ban, or Muslim ban as we see it, that basically barred entry for 90 days for nationals from the 6 predominantly Muslim countries, and it also indefinitely halt refugees from Syria. So that led to tons of lawsuits, including from the ACLU, from our organization, from the Attorney General's office here in Washington, Hawaii, Maryland, and tons of other organizations across the state, as well as public mass demonstrations and protests at the airport, as well as chaos on the part of the Border Patrol, Customs, TSA people who were at the airport, because they also had no idea what they had no prior instructions on how to actually carry out this order. So even people who had green cards from the US were actually also barred. So there was just no one was, just chaos really. So there were tons of lawsuits, and then with the lawsuits, they got initial injunctions blocking the government from enforcing it. We actually got our executive director was running through the airport with the court's order on his cell phone on the emergency, because we couldn't find a printer at the airport. And then we ran to the gate and was actually able to pull off 2 gentlemen off of an airplane that were actually about to be deported. So it was a crazy times. So after all the blocks, the Trump administration issued a second travel ban in March, which this time barred entry for 90 days from nationals of 5 countries, so Iraq was removed, and all refugees, regardless of country, for 120 days. So Iraq was excluded, basically in exchange for the Iraqi government facilitation of accepting people back. So what actually ended up happening in exchange for taking them off the travel ban list was that there were mass roundups of Iraqis in the U.S., particularly in the Dearborn, Michigan area, who had old deportation orders, but who were nonetheless allowed to stay in the U.S. on orders of supervision or whatnot. So these people have been in the U.S. sometimes for many, many years, decades even. And it was particularly concerning because a lot of the Iraqis that were actually rounded up, particularly in that community, were Chaldean Christians who have a legitimate fear of being persecuted if they were to be sent back to Iraq now. So several organizations, including ACLU Michigan, filed a lawsuit blocking the initial deportation, the mass deportation, and were able to buy them some time so that they can make a claim for like a withholding or sort of like a protection so that they don't get deported and sent to their deaths. So after those two travel bans and the subsequent lawsuits blocking those travel bans, the government appealed all the way up to the Supreme Court on those blocks and injunctions. And what came down from the Supreme Court was sort of like a compromise. So they blocked the ban for people who had quote-unquote bona fide relationships to the U.S. So basically, if you have an immediate relative in the U.S., you're trying to come visit your fiance who's in the U.S., a U.S. citizen, or if you have already been admitted to a U.S. university and are just coming to go your studies, or you have already accepted a job in the U.S. and was just coming to do your job, they couldn't be banned under this travel ban. But everyone else were blocked. And this included refugees whose only connection to the U.S. were those resettlement agency sponsorship. Basically, a resettlement agency such as World Relief, Lutheran Community Services had gotten the contract to basically help them resettle in the U.S. According to the Supreme Court, even though the agencies has this contract, even though they've already, that their funding actually depends on them receiving this person, that wasn't a good enough relationship, wasn't a strong enough relationship for a bona fide test, and the refugees were still blocked unless they just so happens to be, have a U.S. citizen or lawful permanent immediate relative, or somehow got themselves an Amazon job or whatever. So they were still blocked. So that second travel ban was good for, again, that 90 days. So around, and part of it was 6 months. So around September, just before the second travel ban was set to expire, and just before the Supreme Court was scheduled to hear oral arguments on the original first two travel bans, the government issued a third travel ban, this time not by executive order, but by a presidential proclamation. Again, barring entries from people from predominantly Muslim countries, but then this time they threw in North Korea and certain diplomatic corps and government officials from Venezuela, because we apparently had tons of visitors coming from North Korea every day. But it was really just to, if you ask me, basically it's just to make it look less like a Muslim ban. And because they did this, the government attorneys were able to go to the Supreme Court and basically ask the Supreme Court to throw out the other cases as moot because, that's no longer applicable. We have this whole new thing now, which also spurred tons of lawsuits on the third travel ban. So in December, with the Supreme Court was again asked to review the blocks on this time, the third travel ban. And this time the court allowed it to go into effect pending challenges, meaning that the lawsuits are still happening, but they can actually bar people now. So the bars aren't blocked. So this effectively overturned the earlier compromise regarding the bona fide relationship test. So the court had oral arguments at the end of April. It has not issued a decision yet, but after listening to some of the questioning by the 5 conservative justices on the court, I have to admit I'm not too hopeful about this one, but we shall see. And on the other hand, as I mentioned, for the refugee admission, again, the second travel ban expired, and then right around the time that it was expired in September of 2017, President Trump reduced the number of refugee admissions down to 45,000, which is the lowest the U.S. has had it since 1980s. And the Trump administration also ended the Central American Minors Program, which was a program that was established in November 2014 under the Obama administration in response to the surge of Central American youth that was showing up at the border, fleeing gang violence, domestic violence, everything, that would allow lawfully present parents in the U.S. to request refugee or parole status for their kids back in El Salvador, Guatemala, and Honduras. So in August 2017, the Trump administration terminated the Central American minors parole program and even gone so far as to rescind conditional approval. So there were people who were in the home country who already basically had been pre-approved and was basically waiting to like jump on a plane, were suddenly being rug just pulled under them. And then in November, the administration stopped accepting new applications and the program basically effectively ended at the end of January this year. So there are people who have already come in the US previously under this program whose status basically is set to expire and now will have to find some other way, if any, to try to stay in the US. Which kind of brings me into the children's program, DACA. Okay, so as many of you may know, DACA was a program created under the Obama administration to defer deportation and give work permits and social security numbers to individuals who were brought to the U.S. as kids and who otherwise satisfy certain requirements, like they have to have gone to school or finished GED or be in school, and have to be in the U.S. for a certain period of time, et cetera, et cetera. So in September 2017, the Trump administration, via that Jeff Sessions, AG, announced that they were going to end the DACA program effective as of March 2018. And there was a whole wind down provision basically saying that people who've already had pending applications, will adjudicate them. People whose DACA would expire after March, they're done, they're over. Like there will be no renewals, the thing just ends. Which again spurred tons of lawsuits, and thankfully through those lawsuits, the courts blocked the DACA wind down. So as of now, the Department of Homeland Security, the government, is required to keep accepting renewal applications, regardless of when their status were set to expire. But they are not required to accept new applications for those who've never had DACA in the past, which is unfortunate because with DACA, there's actually an age provision that you can only apply until you hit about 15, 16, depending on whether you're in court or not. So there were kids who were maybe like 6 or 8 when this program came out that never had a chance to apply because they weren't old enough yet and now cannot apply for it. And the government is also will not approve any request for what is known as advanced parole or like travel permission or travel authorization for DACA recipients. And not only does it cut off like travel plans, it actually cuts off a pathway to permanent residency because some of these DACA recipients may be, for example, married to a US citizen and can go through a family visa processing, but they have to go back to the home country to get to the consulate and then come back with a visa/green card. But because they can't travel, they literally cannot get the permanent residency. So it also blocks a pathway for them to get immigration status. And then in May 2018, Texas and 6 other states filed suit to stop immigration agency from adjudicating DACA applications. Thankfully, nothing really has happened since then. And meanwhile, there's all these talks, stalled legislation about whether Congress will actually get their act together to come up with some sort of DACA solution and what that may be. And of course, even within GOP, there's breaks amongst the super hardcore conservative about, that opposes any remedy that they consider to be quote-unquote amnesty versus those who at least want these kids to be able to have an opportunity to apply for something. We'll see. I mean, when Trump announced it, he said that we're supposed to put the pressure on Congress, and yet, how many months later, and we're still on this issue. But I'm hopeful that they will have legislation. The question is just comes down to what the terms may look like and like who will be sacrificed for it, if any. Whether it be whether it be a border or increased interior enforcement, I just wonder what the cost would be. Meanwhile, for the unaccompanied minors, so if you guys sometimes see in the headlines, starting from about I'd say 2014, 2015-ish, there was a surge, tons of kids, particularly from the Northern Triangle, Central America area, that were coming to the southern border, and they were kids as well as women and children predominantly. So these kids who show up by themselves, like without parent or and who are not traveling with their parents, are considered unaccompanied minors. If, at the time of entry, they're under 18 and they don't have someone to take care of them, basically. So the U.S., the way they do it is that they send them to the Office of Refugee Resettlement. So they don't call it detention, but you lock them up, it's basically detention for kids. But the one good thing about being that have this unaccompanied alien children or UAC status is that there are certain protections that apply only to them, thanks to the Trafficking Victims Protection Reform Act, so that these kids are not subject to expedited removal processing. It doesn't mean that they won't be deported; they just won't get deported as fast. But when they have to go through an immigration court system where they are allowed to try to apply for benefits that may qualify for them, so there's more of a due process protection. So the Asylum office, which especially here in the West Coast tends to be a little nicer and more human than the immigration judges, also have jurisdiction over their asylum claims, and the kids are actually exempt from any filing deadlines for asylum. But under this administration, the government attorneys and immigration courts have been arguing that the kids lose their UAC status once they turn 18 or once they've been reunited with a parent. So let's say they came at the border, they were 6, and they got into the OR custody, and OR custody, which has to take into consideration the best interest of the child, placed them with maybe his mom, who's already in the U.S. But now the government is arguing that reunification stripped them of the status and stripped them of those protections, and that the Asylum office has no jurisdiction to grant them asylum, because they no longer have those protections. So they'll argue, and the immigration court judges, which actually report to Jeff Sessions, are now authorized to revisit their designation and also strip them of the status, or try. The Asylum office, which is actually under a different department, actually that does not respond to Jeff Sessions, hasn't received any, they don't have any orders from above to deny asylum cases for these kids. So for the last couple of years, we've been trying to squeeze the kids through as fast as we can, so that they can have a shot in front of the asylum office and not in front of the immigration, and not be forced to appear before the immigration judges, which are much harder and much more traumatizing for the kids to go in court. So we shall see. And many of those unaccompanied minors particularly also qualify for what's known as Special Immigrant Juvenile Status, or SEJs, which is a protection that allows youth under 21 who have been abandoned, neglected, or abused by parents to apply for permanent residency in the U.S. and be on a pathway to U.S. citizenship. What we did see, again, with a lot of the surge kids is that they came alone for a reason, and many of them, unfortunately, have suffered child abuse. In Washington, and actually in many other states, in order to get the SEJs status, they have to get a youth court or family court or something like that to issue a finding that they have been abandoned, neglected, or abused. So in Washington and many other states, the courts will only issue dependency filings, which are required to apply for SEJs if the filings were filed before the youth turned 18, even though federal law allows them to be up to 21. So NERP and also Columbia Legal Services partnered up, and we actually pushed a new legislation. And the Loom Law was signed by Governor Inslee in May 2017 and went into effect as of July 2017, which created this whole new program called the Vulnerable Youth Guardianship that allowed Washington state courts to appoint a guardian for vulnerable youth, basically between the ages of 18 and 21, and get that dependency finding so that they can apply for SEJs. Meanwhile, as of spring this year, I don't exactly know when exactly it started, because immigration changed their interpretation unannounced, just reversed it, claiming that the applicant no longer qualifies for SEJs after they turn 18, where they're doing it on the argument that the state's courts authority, who, like I say, not under the youth guardianship, but in most states where they do only limit to 18, that when the state court authority ends, then the kids' eligibility for SEJs also ends at 18. So they claim. So now they've been denying these cases, which for the past 10 years have been pretty readily approvable, especially after you already have a state court judge finding that, yeah, the kids has been abused. And not only are they denying applications, they're also going above and beyond and revoking approvals. So taking away the kids' green cards. I know I shouldn't really be surprised anymore with what happens with this administration, but to go after youth who have been abused as children and to take away their green cards, it's a new low. Yeah. And recently, what's been in the news a lot is regarding the quote-unquote the issue of the U.S. government losing track of nearly 1,500 unaccompanied minors, as well as the separation of parents and children. First off, I want to say that these two issues have been in the news and social media a lot, but I do want to clarify that they are two separate incidents, and it has unfortunately been conflated a lot in the news. But I just want to get the facts right that they are separate. But they're both still morally reprehensible. So the first issue, what happened with the losing of the track of 15 unaccompanied minors? So again, as I mentioned earlier, all these unaccompanied minors that show up at the border, the U.S. government will take them, and then which will try to place them with a parent or other adult sponsor, probably before the kids turn 18. If they're not able to find a sponsor before the kids turn 18, the kid actually just automatically gets transferred to the adult immigration detention center on their 18th birthday. And we unfortunately do see several of those kids at the detention center in Tacoma. And there was, after some news outcry, which actually found some of those children that they ended up landing in the hands of traffickers and were at an egg farm being used for forced labor. So they sent out these surveys to the sponsors asking like where the kids are basically. And there were about 1,500 of them that they received no response from. So they've lost track to about 1,500 unaccompanied minors. And in response to the outcry, the government response was basically saying, not our problem. We're not, quote unquote, not legally responsible for them. Once they've been released, they're not our problem. And the other issue is the separation of the parents and children. So there was already talk about it even before this year, about Trump administration even considering it as basically as a deterrent. Like if you come to the US, we try to come to the US, we will take your kids away from you, basically a threat. And as of May, so earlier this month, they rolled out the quote-unquote zero tolerance policy, where they would start prosecuting parents for illegal entry who show up at the border with their children. And because when the parents go through criminal prosecution, they will be detained in criminal custody and go through the mass courts. The kids can't be detained in criminal custody because they haven't committed a crime. So the kids ended up being separated because they're locking up the parents and the kids need to go somewhere. So they're putting them through the ORR custody. Which again, then ORR will try to release them to someone, but you also just locked up the parents, so who are you going to release them to? But anyway, so again, just to give you a scope of like how big of an issue this is, just in the first 2 weeks of May, there were over 600 parents traveling with 658 who were prosecuted in those 2 weeks. And when they say traveling with 658, that means those 658 children were separated from their parents. And that level has increased. I think the percentage is now like there've been a surge of about 20-something or 30% surge of prosecution of these type of cases. And the kids' facilities are already at like 95% capacity. So at some point they get run out of bed space, and then they're already kind of trying to figure out where to stuff the kids. And there were even proposals about stuffing them on military bases, which actually did happen during the 2015 surge period temporarily. So we may be going back to that issue where the kids are literally sleeping on the floor in military bases. And again, in response, John Kelly's comment was that don't worry, the kids will be taken care of, put into foster care or whatever. And this separation of children and parents applies even to asylum seekers, which I think is a violation of international human rights, because if they show up at the border and they present a credible fear of persecution upon forced return, they have a right to seek asylum. As a matter of fact, that's U.S. asylum law. In order to qualify for asylum, requires you to somehow get to the U.S. first. So they came, and then you prosecute them. So this is really concerning for the asylum seekers, and especially now that the kids are being separated with them placed in custody, they're likely to spend much longer time in shelters or foster care, especially after you just locked up again. You locked up a parent, so who are you going to release them to? Temporary protected status. So this is a form of protection for nationals from certain designated countries who are unable to return to the home country due to armed conflict or national disaster. For example, when Nepal had the earthquakes situations, they were given special protection that they can apply for because the infrastructure in Nepal was so bad that they can't really accept them. So the Trump administration has announced termination for multiple programs, including for Nicaragua, Haiti, El Salvador, Nepal, and Honduras, and all of them to end somewhere between 2019 and 2010. And some of these programs have been around for many years. So you're talking about individuals like for example, the Salvadorans and Nicaraguans, they've been in the U.S. for decades, 20 years or more, who now and have been receiving temporary protected status many times over and have been re-registered many times over, allowing them to stay. And now they're basically saying, you're not welcome anymore, pack up. And this again we're talking about really separation of families because again, they've been here for 20 some odd years sometimes. So we're actually so now all these people whose applications are set to expire is also a wind down program. So many of them, if not all of them, have one more chance that they can re-register. And I do really highly recommend that they do, at least just to get that one last period, because there's actually case law in the 9th Circuit, which is basically West Coast in Arizona, and 6th Circuit, which is Michigan, Oklahoma, Tennessee, I'm forgetting the other one, maybe Ohio. Sorry to anyone from Ohio. That basically say that people with TPS who have approvable immediate relative family petitions can apply, or may apply for permanent residency. And it's only for those people living in those states. And the 9th Circuit case is actually one of our cases. But under our interpretation of those, of at least our case, it requires them to maintain a valid TPS status. So if their TPS is about to expire, they should re-register so that they remain in status while they try to see if they can apply for a green card through a family petition or something and not lapse. But for everyone else, they really should be thinking and talking to immigration lawyers to see if there's any other options for them to stay. I know some of them have been here for many years, so they've been content with what they've got, and they haven't really revisited their immigration status in a really long time. But now it's really the time because times are ticking. We're hosting a clinic mid-June, I want to say June 15th, I need to double check my dates, for a community-wide clinic where we'll do immigration consultations for TPS holders to see if they have any other options. Okay, enforcement priorities. So around the same time as the travel ban, which actually this one didn't get as much coverage because of all the craziness from the travel ban, the president also issued an executive order basically expanding the DHS or ICE enforcement priorities. So under previous administrations, the Bush administration, the Obama administration, they basically tried to focus on people who had criminal records. That's not to say that people who don't have criminal records weren't deported. They still were, but at least there was a policy in place, concerted effort, to try to focus the government's resources to go after those with the most egregious criminal records. But under this administration, they basically threw that out of the way and put in these new enforcement priorities that includes people who have been convicted of any criminal offense, so regardless of the level of severity, charged with or have been charged with any criminal offense. So even if you don't even have a conviction, have committed acts, again, without a conviction, have engaged in fraud, the scare about public benefits, subject to a final order of removal. So if you had an old deportation order but was allowed to stay in the US, no more. And The lastly is in the judgment of an immigration officer, otherwise pose a risk to public safety. And it's such a arbitrary, like just open-ended hunt. I mean, basically, if someone decided that they want to arrest you, they can arrest you. That's what it really means. So now we're talking about increased enforcement against those with family ties in the US, with no criminal records, and increased detention of them. More collateral arrests, which is what happens when, let's say, ICE has a warrant for this one particular individual, and they show up to the neighborhood, and they see other brown people. In the past, because of the warrant, they had to go after the guy whose name is on the warrant. Now, anyone that they can approach while they're out on the field, they can arrest collaterals, like your plus ones, basically. So now they can arrest collaterals, and also workplace raids, which we've already seen, which under the Obama administration for about good 6 years, so we didn't really see that many. But we've already been seeing a workplace raid come back. Renewed action in deporting those with old deportation orders. Again, there may be some who, for many reasons, maybe because the government didn't accept them, maybe because they were stateless, maybe because they had humanitarian reasons, such as like they're the primary caregiver for the wife who has stage 4 cancer or whatever, that the government had allowed them to stay in the US on a humanitarian basis, even though they had an old deportation order. Now the government is renewing interest in deporting them. And then many of them were previously placed on an order supervision where they have to routinely check into ICE, and it usually is like a very, very mundanely like, yep, still here. But now there's a chance, and we have seen, so it's not just a matter of a possibility, but we actually have seen people getting detained when they go into the routine checkups. There's also the concern regarding the risk of applying for immigration benefits. So in certain situations, the immigration agency will actually place people and refer them to deportation proceedings if, say, the application for a certain benefit was denied. This is the case with asylum applications. If someone loses in front of the asylum office, they more or less automatically just gets transferred to the deportation proceedings. But there were cases such as DACA applications, U visa applications, C visa applications, where if you just don't qualify, they'll just say, yeah, no. But that's about the extent of their action, unless you have a really, I don't know, if there's like Interpol warrant against you or something like that. But now there's a concern that even for those who have been denied for just stupid reasons like, oh, you were 1 day short of the period, so that you don't qualify for DACA. But in the past, where they were like, okay, you just don't get it, you lose your application fee and that's about it. Now there's a concern risk that those information will then be turned over for enforcement issues, for enforcement. And one thing that's not necessarily written into law, but because of a lot of the anti-immigrant rhetoric, and now with the backing of the president, many ICE officers also feel emboldened. They feel like the shackle has been taken off, so that they have started arresting in or near sensitive areas. So previously, again, under the Obama administration, there were areas that ICE had a policy not to really go into, including schools and hospitals. But now we have seen reports of them going. I mean, there was a whole a news report about the girl, the 10-year-old, the cerebral palsy, who was picked up by ICE right after she was released from surgery. Jesus. But anyways, ICE actually followed her family to the hospital. She had the surgery, and then when she was coming out, they arrested her.
Where was that?
Texas, if I remember correctly. But yeah, now we've also seen reports of ICE agents going to courthouses, which is particularly concerning because there are many reasons why immigrants go to courts, not necessarily because they are defendants, but also because they are witnesses, because they are seeking protection orders. So now they're afraid to go to court because ICE is stalking at courts. And also arrest of DACA recipients. Here even we have this one big case that's gotten national news attention, where they arrested a guy with valid DACA status while they were going after his father, and he was the collateral, and they just picked him up, ignoring the fact that he was in valid DACA status, and then later justified it by claiming that he was a gang member, and then forged or technically erased his statement and forged his document where they claimed that he admitted to being a gang member. It was actually so shoddy because he wrote it in pencil and it was like, I am not gang member or whatever, and they just erased the front part, so it just says like, yeah, they say I'm a gang member. That's a lawsuit that public counsel have recently been involved with and gotten pretty good results, actually. And kind of in the background of this is that the administration has also been decreasing and cracking down on student and tourist visas and proposed harsher punishments for overstays or violations of their visas, which sounds good, except now they've also got a new interpretation of what's known as unlawful presence. So people who may have violated or overstayed their student visas unwittingly or like by mistake, in the past they don't usually accrue lawful presence, now they do. And when they do, it actually triggers potential bars to return. Like if you've overstayed for 6 months, you're barred for 3 years. If you overstay for a year, you're barred for 10 years. And that could happen, like again, if the student doesn't even realize. I mean, usually what we see when they trigger something like this is, let's say a student got sick and he unfortunately had to drop to part-time from his full-time study, and that was a violation of his student visa. And then not only does he have to deal with the fact that he couldn't continue his studies, he was sick and all that stuff, now he has to risk the issue of deportation and bars from entry. So what has been the impact with all of these is that it's just a lot of fear in the community, and in some sense that's kind of the goal, right? For a lot of immigrant communities, they now have a fear, I mean even more than before I would say, of any contact with any law enforcement agencies, even if they were reporting crimes when they're the victims, going to court including to obtain protection orders. And for a lot of them, they don't differentiate between local police versus ICE, because they're afraid that their name is in the system and that their information will be shared, which is why the sanctuary policies are so important. They're afraid of accessing public benefits, especially with Trump's talking smack about immigrants being a welfare drain and all that stuff. And as well as medical services, because they're afraid of being seen as a mutual, or if you will, a burden on society. Because in immigration law, there's something called what's a quote-unquote public charge, which is a charge against you that can result in you being denied permanent residence or even entry to the US. So the public charge, first of all, does not apply to asylees and refugees. But again, a lot of the immigrant community, they hear rumors and they get scared. So if your patient is an asylum refugee, they should not have to worry about this. They're entitled to receive public benefits. As well as like people who have UNT visas, VAWAs, SEJs, they don't have to worry about the public charge. What is a really big issue are those who are doing, for example, family visas, work visas. And the administration has proposed changes to the interpretation on this public charge issue, whereas previously, if you access like health, nutrition, or other non-cash emergency programs, it would not count against you. But now they will count just about anything. And not even just programs that you use, but programs that your US citizen children use, or even your families use, even though they are legally entitled to use those programs. And this will likely lead, and there's tons of like scholarly papers about the impact on the immigrant community, on participation in medical aid and health coverage, going to doctor's appointments, applying for emergency food or food stamps, or even educational programs like those like pre-K, what's it called, Head Start programs. Under the proposed rule where they like count everything, that technically is a government program. So I do wonder if you guys have been seeing a lot of like cancel appointments, or people are afraid to apply for insurance or even charity care or anything like that just because of this rumor concerns. And in the immigration court and the immigration agency, what we have seen is tons of challenges to due process. So Jeff Sessions has proposed what is known as performance reviews for immigration judges, so basically quotas. So now you're not judged on like how good of a job you do as a judge, but how many people you deport, basically. And the immigration judges union has fought back on it, but I mean, technically he's the boss. Expedited case scheduling, which again, in theory sounds good because like you get your case heard sooner, but they're actually scheduling them so quickly that you don't have enough time to find an attorney or prepare for your case. I'm seeing, for example, asylum offices for new filings, like filings that were filed after like end of January this year, they're getting interviewed in a matter of like 2-3 months. that is not enough time to find an attorney, get medical evaluations, get psych evaluations, do declarations, get country condition reports, get audit reports, everything. And the goal, I mean, the unspoken goal is basically the sooner we see you, the sooner we can deny you. As a matter of fact, they even issued this pilot program where they started sending notices to people who apply outside the 1-year deadline, who are saying like, hey, we've noticed that you filed too late. Would you like to just skip the interview? And the parenthesis, which they don't really mention, is that if you skip the interview, you automatically get placed in deportation proceedings. So they've also been limiting access to legal assistance to unrepresented individuals. So for those who were not able to afford to hire private attorneys, they again have to represent themselves. So shortly after we filed a lawsuit on the first travel ban, we received a cease and desist from the AG's office to stop providing pro se assistance, basically like legal aid assistance for people who don't have attorneys. And it's kind of funny because the letter actually personally called me out, like my name is mentioned, because I do a lot of this. It's kind of my job. But so then we sued back. So we sue Jeff Sessions, asking the court to block the Attorney General from enforcing the cease and desist letter. And we actually got an injunction against the government from enforcing it so that we can continue doing what we do. But meanwhile, the lawsuit is still going on. And maybe that's kind of the goal, right? Even if they can't win, they at least can drain our resources and divert our attention from serving our clients. Jeff Sessions also proposed, actually he announced that he was going to cut funding to the legal orientation programs, which we are part of, as well as tons of other civil rights organizations that provides legal orientation, know your rights to detainees, to kind of give them an idea of like, hey, what's going on, because no one tells you there, what's going on, there may be some benefits that you qualify for, would you like to talk to an immigration attorney type programs. And he announced that Jeff Sessions announced that he was going to cut the funding for these programs, and then which caused a lot of outcry amongst certain members of the Congress, tons of civil rights groups, advocacy groups like us. And then about, I say like 3 weeks after, he reversed and actually said that like, okay, we won't cut it off right now. We'll review it for another year. And then it may have something to do with the fact that on the day that he announced his reversal was also the day that we were preparing to file a lawsuit against that. So we will see what happens in a year, but if they come, we're ready. Like literally, we've got everything written. Just come here. So we're ready. And what on the other side is that we've seen that USCIS or immigration has been issuing more interviews for cases that previously were like pretty easy to approve. Like, for example, where cases where you just have to prove, biological child relationship, given a birth certificate, it's like, yep, nope, that's my child, check. But now they're issuing more interviews on those. And I've gone to several of those interviews that last like 15 minutes, it's such a waste of time. For the officers, for me, for my clients, especially if they have to drive like 3 hours to get to the interview. And requesting more evidence. So I've had cases where we had legitimate birth certificates and everything, and now they're asking my clients to do a DNA test, which costs a lot of money for my indigent clients. And also more delays. My refugee green card applications or asylum green card applications that previously had taken like, 3 or 6 months, and now routinely taking more than a year. And they do it more than a year because the medical examination expires after a year. So then if they stall it for long enough, you'll be required to redo your examination. I mean, that's maybe not the reason, but that's the impact that we've been seeing for our clients. And then we've also been seeing tons of decrease in end of prosecutorial discretion. So again, under the previous administrations where they tried to focus on like the ones with the worst criminal records, you were able at least to make some sort of deal or like have ask them to basically close the case for someone who's like, hey, look, he's got 4 kids, he's a sole provider, he has no criminal records, just let it go. But now they won't agree to anything. And the Jeff Sessions actually issued a decision ending administrative closure so that you can't forestall these cases. And then he's also recertified a case to himself that was a grant of asylum based on domestic violence, and now asking people like whether individuals who suffer crimes by private actors could qualify for asylum. And this includes domestic violence claims. And that was what the case is about. So we're really concerned that he's going to actually come out and say, no, DV doesn't qualify for asylum. But because of how broadly he asked the question, like private crimes, that could be anything by non-government actors, so like FGM cases, sexual orientation, like hate crimes, which is usually not necessarily by the police, but by mob, by society. Let's see, forced marriage, forced circumcision, those cases. Like that could cover a lot of claims that traditionally has been granted asylum, and Jeff Sessions may actually change that. Backing up a little bit, sanctuary policies, especially with the increased interior enforcement, I kind of do want to touch on like why these local issues are so important, because it basically limits the sharing of information to ICE, right? So first of all, sanctuary just refers to policies that prevent local jurisdiction, like the city, from using their own resources to help with immigration enforcement. It doesn't mean that like in Seattle you can't be arrested by ICE. You can, that's why we're there. But it just means that the city government won't go out of their way to refer someone and use their own resources to do so. In certain in limited circumstances, like if like I say, if they got an Interpol warrant, they have criminal records and they can do it. But otherwise, they're not supposed to. So, so here it means that the local police will not cooperate with ICE, or that local jails will not hold people on ICE detainers, which are unconstitutional. But it doesn't mean that ICE agents cannot, on their own, engage in enforcement activity in that jurisdictional location. And as a matter of fact, we've seen an increase in that in response to the sanctuary policies. ICE being basically saying like, you guys have these policies, so you made us go into courthouses so that to arrest people is now their excuse. And here, I mean, we are lucky enough that we live in a pretty pro-immigrant community, but even in, I mean, it's not always the case in Washington, right? We've had situations in Tequila, we've had several lawsuits against Tequila, Yakima, Spokane, on like discriminatory policies by local enforcement and counties. And even in the state of Washington, we still have issues. I mean, the Attorney General has actually sued Motel 6 for volunteering providing guest lists and information to ICE. And then it was found out that our own Department of Licensing was also giving information to ICE. So instantly order DOL to temporarily stop giving personal information, and then DOL also changed their own policy that started to stop requiring court orders when ICE comes knocking, and to stop collecting information such as place of birth that has nothing to do with like whether you qualify for a driver's license, so why collect it. So that could be misused. And then it turned out that City Light was also giving detailed customer information, including like social security numbers and everything, to ICE in 2017. So Mayor has actually introduced protocols in early 2018 for handling these requests from ICE. So again, now you have to like prove that this is for a criminal investigation, not just because you were curious. And routing those requests to her legal counsel office, so that you're supposed to like at least have a secondary review as to like whether you're entitled to get those those information. This is particularly concerning because we actually were able to track down a case where an ICE agent just like sent an email to City Light for information regarding this particular individual who has been very active on DACA and was a political activist on immigration issues, for her information, and about like 2 weeks later she got a deportation order. So we've been busy. Again, in addition to our individual cases, we've also been doing challenging the Muslim ban, the travel ban cases, as well as the CART program, which is it was legitimately a secret program where they would discriminate against Muslim Americans and black hole their cases for immigration benefits. So if you have a Muslim American name and you wonder why your citizenship applications have been stalling for 10 years, it's because they black hole you and they didn't tell you about it. So we have a lawsuit on that, and got actually injunction on that. We also won the preliminary injunction against the government cease and desist letter, like I said, so we can continue doing our work. We also won the ability for the TPS case I mentioned earlier. That was one of our cases. And we're continuing to fight for right to counsel for children in deportation proceedings, because we think that, like, okay, even if you don't have right to appointed counsel, you should, they're kids, come on. Like, the kids should not be expected to represent themselves. So we're trying to do right to appointed counsel for kids in deportation proceedings, as well as defending the right to bond hearings for those who are detained so that they are not detained indefinitely. which really affects not only their mental capacity being detained, but also their ability to get counsel, because I can tell you it's much, much harder to find an attorney and have the resources to pay for an attorney when you're locked up and being forced to work for the jail. There's another lawsuit by the AG against the detention facility on because the detainees were being paid $1 to $2 a day to do work inside the jail. And then we also had a lawsuit challenging the one-year deadline issues for asylum seekers. So in general, asylum seekers are required to file within 1 year of the last entry. What we were seeing is that, especially for those surge cases, ICE would detain them, and sometimes they won't even release them before 1 year. So then the deadline lapses, and then they don't tell these people about the deadline. So we sued them, the government, and then we actually won a judgment, so that for those people, they now have an extended time period to apply for asylum. And then we also have lawsuit against, there was an ICE attorney who was submitting forged documents in immigration court. He got criminal prosecuted, but then now we're also going after him for civil damages. And then we also, again, has suit against the local police in Tukwila and Yakima, Spokane counties on immigration enforcement and detainer issues. Spokane, we actually won a settlement, but I think Tukwila is still going on. So on our website, there are tons of resources. If you just click under the resource tab for things like sample parenting plans, like just emergency stuff that it's good to just have in case, like what to do if I'm arrested and I can't pick up my kid type issues. But also things like we continuously update our community advisories on DACA, especially when the lawsuit was going on, everything was changing like by the day. And then we also have news and events. So we do tons of community clinics, education workshops across the state. So if you're interested, feel free to check them out. And then if you have any patients, clients that may need our services or need legal help, we do our general intake and as well as specialized workshops for family visas and asylum. And our general intake is everything, including like U visas, T visas, family visas, citizenship, just about every immigration, deportation defense, just about everything except for student visas, because those are handled by the school, and work visas, because those are usually handled by the employer, and none of our clients who are low income qualify for it anyways. Oh, and entrepreneur visas, for the same reason. None of our clients are rich enough to qualify for entrepreneur visas. And then if you have detained clients, we have an office in Tacoma where they can call the numbers and just, if possible, leave their name and a number, and then we'll try to find them in the detention center and try to talk to them. In Washington, which there's also a network, the Washington Immigration Solidarity Network, that has a hotline that we're a part of to report immigration activities such as active raids. So if you see like tons of ICE agents wearing the vests surrounding this restaurant and you have no idea what's going on, report them, please. And we also have the Washington Defenders Association Immigration Project. This is a service for criminal defendant attorneys who may be representing immigrant defendants, and they're trying to avoid immigration consequences, or trying to mitigate immigration consequences for the clients. And in Seattle, the city also actually put away some money to set up a legal defense network that we're a part of. And to qualify for that assistance, they have to be an immigrant in detention, facing deportation, or otherwise in danger of losing immigration status. They have to live or work in city of Seattle or King County, and they have to be low income. And they can contact us through that number or even just our general number. And there's also tons of, in addition to the lawyers that are involved, there's also tons of community navigators, the Filipino community, the West African Community Council, the Seattle Park, that does a lot of the support network too for them. I know this is kind of limited because, as you may know, a lot of the increase in property value pushes out a lot of the immigrant clients out of King County. But if they do have someone like a school, a kid who goes to school in King County, if they work in downtown, even though they lived in Pierce, they could still qualify. Okay, questions? Oh, we're on time. Okay, yes.
Hey, Maggie, could you describe an ICE warrant and the status of an ICE warrant?
Okay.
An ICE officer turns up on the wards and asks to see somebody's patient.
Sure. So even though it's called a warrant, an ICE warrant isn't actually a warrant. So the difference is that when you think of warrants, like in the general legal parlance, like general cop drama parlance, if you will, it's someone like they have gone to the judge and asked for a specific warrant to arrest one person or search a specific property because they think something has gone wrong, like a crime has been committed, and they have to show evidence that at least prove that, like, yeah, we've got enough evidence that makes this person a suspect in this case. And the judge has to go through the evidence, like, yep, this looks like there's enough evidence you've got going on, and then they will approve the warrant or sign the warrant. An ICE warrant has none of that protection. It's literally just some guy, ICE officer at his desk who like, okay, I'm just gonna sign it myself. And those are not warrants, insofar as it does not give the ICE agent any legal authority to just like kick down the door and do a raid, or detain someone based on just that. If the ICE agent actually shows up with an ICE warrant, you can basically just like, let me get my supervisor and just kind of ignore them, or at least direct them to, because that does not give them permission to enter into sensitive areas and private areas. The only ones that are allowed are the court orders, and you can tell because they've got the headings of a court and not, the emblem of ICE on it. I mean, I would say if you guys have like I don't know, contact, if you were at the front desk, like, I think you guys should have a policy on what to do in those situations, on like grabbing a supervisor, grabbing, I don't know, phone call to legal counsel, whatever your office connections are, and able to differentiate between the two. The ACLU actually has great resources online where they have samples of what they look like so that you can tell at first glance what they are. But like I said, the most giveaway is this issued by a judge. No? Ignore.
We have to finish up because we're over time, but I think that I'm sure people have questions, so please join us at that front. We'll just thank her for
Thanks for having me.